The physical hearing upstairs in the circuit courtroom is being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In Re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as a arraignment attorney on behalf of Beth Bridgman.
Right, good morning,
Also, I will represent myself.
Yes,
Okay.
we'll get to that.
I would like to say I'm here on special appearance. No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back. I don't know how I'd pull the chair up, so thank you.
Well, if says that, I have no problem. All right.
Thank you.
All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it. Says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore, I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the 2 contempt citations pending against you. You have the right to have a hearing on both of those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a statute.
what is MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know? Well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail.
Right out of the gate, we are in full sovereign citizen territory. Special appearance, living soul, strong man of the all caps. If you've watched enough courtroom breakdowns, you already know what's coming, and it's never subtle. This isn't just someone confused about procedure. This is someone actively rejecting the legitimacy of the court while standing inside it. That contradiction alone tells you we're in for chaos. Because here's the reality. Courts don't operate on YouTube law, Facebook memes, or common law living soul arguments. They operate on statutes, rules of procedure, and precedent. Indy, the judge, he immediately recognizes the script. Calm, controlled, not taking the bait. But you can already feel the tension building. What makes this case especially explosive is that it's not even a new criminal charge. This is contempt, meaning she's already in trouble for what she did inside the judicial process itself. Stay locked in, Because when sovereign ideology meets procedural reality, somebody
The maximum penalties I outlined for you.
I think that I would like to wait. I have a call in to the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause, and she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting.
debating metaphysics. He's explaining something very simple. You were ordered to appear. Instead of appearing, you return the document cut into strips with red writing declaring you reject. The contract contempt of court isn't about whether you believe in jurisdiction. It's about whether you complied with a lawful order. And physically altering and rejecting a show cause order doesn't invalidate it. It strengthens the court's position that you knowingly defied it. Notice the judge's tone. He doesn't escalate. He doesn't mock. He just states the sequence of events. And that's important because when someone is trying to provoke the court into reacting emotionally, calm authority is the most powerful response.
Did you just understand what the judge asked you regarding those two charges?
Did you just understand that I think there's a bigger overriding issue?
But
Thank you.
Hang on.
Thank
I'm
you.
not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank
you
you.
and Ms. Bridges.
I guess I just like to, state that
well, I think we need to
she's
back it up.
pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future
Okay.
hearing.
No,
Honor,
but
I
all
just
of my
want to-
rights were strongly impinged upon for even when I never failed to appear.
Okay. We're going to have a hearing where you.
She
can
was
present
working,
that.
okay,
Okay, you're going to get your
Mr.
hearing.
Villanueva,
No,
I'm
this
directing you to
is-
stop
thank you.
arguing with Ms. Bridges.
Okay.
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized show cause.
All right, if she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
Well, she
today's
was
purpose is
investigating,
to-
okay.
Today's purpose is to advise you of the two contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask, what statutes or what law or what are you saying here are the charges? Because this does not match, sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay?
I've
It
told
does
you
not
the-
say,
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
why have they changed,
I'm
Judge
not
Becker?
answering that question.
Can the prosecutor?
No,
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? Do you wish to represent yourself and not have an attorney represent you?
Yes, I
Okay.
do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are those,
then I'm going to appoint
not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
The judge carefully states the court, the location, the public access, the case number, and the nature of the hearing. That might seem routine, but it matters. When someone is challenging jurisdiction, the court responds by clearly establishing jurisdiction on the record. Also notice, This is a contempt matter tied to an underlying criminal case. That means she allegedly interfered with proceedings involving another defendant, specifically preventing that person from meeting with a Michigan Indigent Defense Commission attorney. That's serious. Unauthorized practice of law plus interference with representation. Courts take that extremely personally because it directly impacts someone else's constitutional rights. This is no longer just about ripping up paperwork. This is about alleged obstruction inside the
What your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and over $7,500 fine. You understand it.
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gothier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
It's
common law
not about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances. You did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty to those, correct? Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you.
Sovereign ideology usually means I'm here, but I don't consent to your authority. The problem? In modern courts, appearing physically and engaging substantively often defeats that argument entirely. The judge even asks her what it means to her. That's strategic. He's giving her space to define it. And she responds with living soul and strong man of the all caps. Classic sovereign terminology. But here's the legal reality. Courts recognize legal persons, not metaphysical distinctions between lowercase and uppercase names. That what's fascinating is how the judge keeps saying, we'll get to that. He's not dismissing her outright. He's maintaining structure. Because procedure is king and
That's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will. I'm not
Okay,
gonna argue
and
about what they are.
the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now,
What is
Okay.
what one do you have?
and this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items checkmarked here.
This is after the fact. So then you added a different charge than the previous one about the same date.
Ma'am, he read two charges.
What I'm, please, Judge Gothier.
Sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one,
Would you I'd like to see what she has
But-
here?
I just, so if you
okay,
don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failure to show.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
She physically came to the courthouse, submitted a mutilated copy of the order with "Your offer to contract is not accepted" written on it, and then left. The judge methodically outlines that a warrant was issued not just for failure to appear, but for the underlying alleged interference with counsel and unauthorized practice of law. Two separate contempt citations, each carrying up to 93 days in jail and a $7,500 fine. This is no longer theoretical. These are concrete penalties, and the judge is making sure she understands.
What is the date of the first show cause?
December 20th.
No, the December.
Sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then
So-
send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do. And
Okay,
that is a hearing date. Today, we're going to schedule a hearing date, and you can present that evidence at that time.
and how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury
for
in
a contempt charge?
So I
Oh,
can
so
schedule
this is a perfect, nice little tidy package for everything. I see.
She's eyeing those papers like she's about to rip them up and start doodling with her favorite red crayon again. At this point, every court doc is just another page in her personal coloring book.
Okay,
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that, state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then. That gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long
No.
as I'm convinced that you're doing so of your own free
Okay.
choice, that you understand what's going on, and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath,
Okay.
yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If
I
you want
can't
to subpoena somebody, what you would do is you go to the court clerk, they give you the paperwork, you'd fill out the subpoena, they would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the.
She pivots to an argument about a state trooper allegedly telling her the show cause couldn't be issued because she wasn't under bond. That's her justification for ignoring it, but here's the issue. Even if someone informally told her that, law enforcement doesn't override a judge's signed order. Only a court can invalidate a court order. And notice what the judge says. If she told you that she didn't have the authority to do so, reliance on bad advice is rarely a shield against contempt.